Hello, and welcome to Environmental Laws, Thompson Hine's environmental law podcast. And in each episode, you'll hear from subject matter specialists at Thompson Hine and sometimes special guests on current events and hot button issues in environmental law topics covering land, air, water, and safety laws. I am Tanya Nesbitt, a partner in Thompson Hine's environmental practice group. I reside in our Atlanta office. I'm also co-leader of the firm's Greenwashing Defense and Litigation team. While I regularly handle all types of environmental law, I specialize in environmental and ESG litigation. In today's episode, we'll be discussing the intersection of ESG and antitrust. Here to join me in this conversation is my fellow colleague, Caitlin Thomas. Caitlin is a partner in our Cleveland office and specializes in antitrust law. Welcome to the show, Caitlin.
Thanks, Tanya.
Just to start off, can you tell us a little bit more about your practice here at Thompson Hine?
Sure. As you mentioned, I'm in the business litigation group and I focus on antitrust, competition, and distribution work. My practice focuses on both the litigation side of the antitrust world as well as counseling. I've litigated antitrust cases from both the plaintiff side and the defense side, so I have experience pursuing antitrust claims as well as defending clients against antitrust claims. And as I mentioned, my practice also consists of counseling clients, which includes best practices for complying with antitrust laws, drafting guidelines for companies for complying with antitrust laws, as well as complying with distribution and franchise laws.
Thanks. So I'm really excited about our conversation today because in the past few years, I think we're getting more questions from clients, particularly those that are working and moving forward with goals in the ESG sustainability space. Unsurprisingly, and as I'm sure you're aware, there has been pushback to that. And more so on the state level, there have been a number of letters and coalitions that have formed to essentially challenge companies using their market influence to set climate agendas, essentially, or climate goals. And we see a lot of this as well in other areas of ESG, for example, like the DE&I space. And so in the past couple of years, there have been some pretty high-profile correspondence sent by state attorney generals challenging industry coalitions, for example, to set things like net zero targets and essentially accusing these companies of really making decisions about policy that perhaps left to elected officials and accusing them of violations of the antitrust laws. And some of this correspondence has actually requested information from these companies or alliance members. For example, they want to know sort of why companies are joining these groups. There's been a push to request information about the detail of conversations being had and any sort of interim targets or pledges that are being made. I think an example of this happened with the UN aligned Net Zero Alliance a few years ago. I would like to just give the audience sort of to set the table. What really is, I guess, at the center of the antitrust pushback in relation to the ESG movement and sustainability movement?
Yeah, so the anti-ESG challenges are rooted in Section 1 of the Sherman Act, as well as similar state laws, which basically mimic the Sherman Act. And these laws prohibit agreements that unreasonably restrain trade. The antitrust laws are designed to protect competition and prevent companies from engaging in practices or agreements that unreasonably restrain competition and trade. And so the challenges against these ESG initiatives, are saying that there could be an unreasonable restraint of trade when companies collaborate, and this could be anti-competitive. It could violate the antitrust laws. For example, if an ESG initiative were to result in a group of competitors setting the same price for a product or paying the same price for an input, that initiative would likely draw antitrust scrutiny. Similarly, agreements that exclude or refuse to deal with a certain third party would also draw antitrust scrutiny as a group boycott. So these ESG initiatives, when competitors are collaborating, they're drawing antitrust scrutiny because the antitrust laws prohibit unreasonable restraints of trade. And the key there is the unreasonable part of it. But ESG initiatives are much less likely to raise these antitrust concerns when it's just a single company engaging in independent and unilateral initiatives. If a company is forming an ESG initiative or pursuing ESG policies on its own, it's very unlikely that they're going to draw antitrust concern, because the antitrust laws are really focused on those competitive collaborations or agreements.
Yeah, thanks for distilling that, because I think one of the concerns has been that these letters or the correspondence from the state attorney generals are just so generalized that people aren't able really to tease out sort of the allegations specific to the antitrust laws that are alleged to have been violated. So going back to sort of law school for me, I recall learning a long time ago that there are obviously exemptions, if you will, for potentially conduct if entities are sort of lobbying around certain set of issues. Like, for example, I believe there's like an educational exemption. So I guess the question becomes, do the proponents of this ESG sustainability movement perhaps have an argument that lobbying around climate issues and petitioning the government on them, right, for policy or legal changes would be constituted as protected conduct under the antitrust laws already? Or do we need do they need an exemption?
Yeah, I think there is an argument that they're already protected if they truly are lobbying the government. There's a doctrine called the Noor-Pennington doctrine that generally immunizes private actors from antitrust liability for conduct related to petitioning the government and other conduct that is directed at the government. So activities that would fall under this protected zone would be public relations campaigns, lobbying efforts, legal actions. And so I think any proponent of ESG that is collectively lobbying around these climate issues and directing their conduct towards the government has an argument that it's already protected under the antitrust laws under this Noor-Pennington doctrine. So as long as the companies are petitioning the government is a genuine attempt to influence the passage or enforcement of laws, there's really not as much concern that this could be an antitrust violation. And of course, the doctrine won't apply if the primary purpose of the collective action is to directly affect the marketplace rather than petition or influence the government. So even if it has that incidental effect of government or judicial action, it has to be, truly for the enforcement, to influence the enforcement or passage of laws, and that can't be a context for it. And also commercial boycotts, which I mentioned earlier, which seem to me to be one of the main antitrust challenges for ESG initiatives, that concern that a group of companies is going to boycott a third party. That would not be protected under the Noor-Pennington doctrine because it's not directed at the government.
So for companies that are interested, for example, in joining alliances or making pledges, I understand that there's something known as a business review letter, which may be a way to be a bit proactive, I guess, about dealing with alleged antitrust challenges or allegations. Can you discuss a little bit what a business review letter is and how a company may be able to obtain one from the Department of Justice?
Yeah, so the Department of Justice Antitrust Division has been willing in certain circumstances to review proposed business conduct and state its enforcement intentions. And this is what's known as a business review letter. It's codified in federal codes, and so it's in there, and any company can request a business review letter. They just have to send it in writing to the Antitrust Division's Assistant Attorney General, and the division will consider these requests with respect to proposed business conduct, which may involve either domestic or foreign commerce. And the important thing about a business review letter is that it's only going to apply to the party or parties who made the request. It's not generally applicable to any party that's engaging in this kind of context. It's specific to the parties that requested the business review letter. So a party can write in, request a review of their specific conduct. They have to provide background information, copies of any operative documents relating to the conduct, or detailed statements of understandings among, if it's a collaboration, the different companies engaging in that collaboration. And so once the party requests that business review letter, the Department of Justice Antitrust Division has discretion to review it or not review it. And if they do review it, they can issue this review letter saying, this is our stance on the conduct. We will or won't enforce it if you move forward with this. But again, the department has discretion to change its mind later on. So you might get a positive business review letter saying this conduct looks good under the antitrust laws. And then a couple years later, the department, may change their policies or thoughts on that kind of conduct and could still go after there later on.
And is there anything available sort of on the state level that may be equivalent to companies that are operating on a state level?
Not that I'm aware of. I think the states usually turn towards the Department of Justice Antitrust Division for guidance. And so, some states may offer similar types of reviews, but from everything I've seen, it's really, you want to get it from the DOJ Antitrust Division because it's going to be a bit more generally applicable and not state dependent.
What are some sort of best practices for how a company might go about making that obviously steers clear of violation of the antitrust laws for their ESG or sustainability programs? Obviously, I mean, I think one obvious way would be to focus. I don't know if there are others that you see from a lens of obviously avoiding sort of potential antitrust scrutiny.
Yeah, so I mean, if collaborating with a competitor, the company should have a pro-competitive, efficiency-enhancing reason for the collaboration. And that's some of the things you mentioned, financial reasons or, increasing or decreasing the cost to consumers or increasing the timing of getting something onto the market. And so if a collaboration has these pro-competitive, efficiency-enhancing reasons for collaborating, they have a business case that the collaboration does not violate the antitrust laws. The FTC and the DOJ Antitrust Division have jointly published a set of antitrust guidelines for collaboration among competitors, which is a very thorough set of guidelines, which goes through, an analytical framework of when a collaboration would be okay under the antitrust laws, when it would violate the antitrust laws, and the factors that the government considers when viewing this conduct or these collaborations. So it's very helpful for companies to look at that, be familiar with the guidelines, and of course engage antitrust counsel who are very familiar with these guidelines to advise on that type of thing. And some collaborations are going to be easier to defend as pro-competitive, such as joint ventures, licensing agreements, trade associations. These are all common in many industries, and they rarely raise antitrust concerns because they typically are pro-competitive and have efficiency enhancing reasons for that collaboration. So if a company is looking to engage in collaboration, I would steer them towards, a joint venture or trade association because there's going to be a lot less antitrust scrutiny around those type of collaborations. Another important consideration is the market share of the companies who are collaborating over ESG initiatives. Under these antitrust guidelines for collaborators that I mentioned, there is a zone of safety if the market share of the companies collaborating is less than 20%, they're going to fall into a safety zone where they're not. So there's very rare circumstances it's not going to raise antitrust concerns. So if you're looking at the market share, you can fall under this zone of safety if the collaborators are less than 20% of the market share. And even when the collaborators are between 21% and 50% of the market share, they're not necessarily going to violate the antitrust laws. There's going to be an analysis that's laid out in the guidelines for collaborators. But again, it's going to be that, are there pro-competitive reasons? Is it efficiency enhancing? Is it going to benefit consumers? So these are the things that the enforcement agencies are looking at and things that companies can consider when they are thinking about collaborating. So that's a general overview of what kind of collaborations or should be pro-competitive and not violate the antitrust laws. If you'd like, you can talk about more specific best practices when companies are engaging in collaborations for ESG that are a little bit more practical and not this higher level of, what you need to be at the first place.
Sure.
Yeah. So, as I mentioned, my lawyer hat on, always seek antitrust guidance from antitrust counsel. We live and breathe this, so we have a good understanding of the antitrust laws and what you can and can't do under them. But some more practical best practices when engaging in collaborations would be meetings and communication should always be properly documented. This would include having a written agenda that are pre-screened by antitrust counsel, and it's important to stick to the agenda items so someone can't say like, oh yeah, it was on the agenda, but then we ended up talking about these potential antitrust issues. And written minutes of the meeting should be taken, again, to show that, we're not talking about anything that could violate the antitrust laws. Any ESG effort should be voluntary and non-binding. Companies should steer clear of reaching an agreement with competitors and avoid mandatory terms. Optional industry best practices, non-exclusive codes of conduct, and elective certification standards are the sort of voluntary and non-binding measures that are unlikely to raise antitrust concerns because they are voluntary and no company who's involved in the collaboration is being forced to engage in them. It's also important not to exchange competitively sensitive information such as pricing and costs. And collaborations or initiatives should not exclude or discriminate against other competitors. Any competitor should be permitted to join the collaboration if they wish to. And there are certain topics that should always be avoided, such as anticipated markets. We always say discussion should look backwards rather than forwards. So don't talk about future pricing or future actions related to strategic plans or output plans, future product development. As I mentioned, you shouldn't exchange competitively sensitive information such as pricing or margins, bidding, profitability, specific customer relationships, and customer pricing or vendor pricing. And you should certainly never discuss companies or contractors dividing the market. We'll take these customers, you take those customers. That would be a per se legal violation. So just things to think about is don't talk about mainly competitively sensitive information, look backward, not forward, and make sure everything is well documented in order to show, hey, we're not violating these antitrust laws. And the last piece of practical advice, which may sound kind of silly, but if a meeting or discussion is steering towards improper topics, make a noisy exit from the room or conversation so it's clear that you're not engaging in that conversation.
Thanks for that really extensive list, Caitlin. And I think that to the top of that, obviously engaging counsel before you are sort of knee deep in any joint conduct efforts, I think is certainly a best practice. And so far, it seems like most of this correspondence has not resulted in any litigation or enforcement actions, but the ESG journey still continues, and so we'll have to see if anyone is able to articulate the basis for a complaint or enforcement action, probably at a state level here. But thank you so much for joining and lending your expertise. And like I said, I think this is a growing area of focus in the ESG space, and we get questions all the time about how to proceed, obviously, in formulating ventures and alliances, et cetera, in light of the increasing antitrust scrutiny. So thanks again for joining.
Thank you for having me.
Thank you for listening to Environmental Laws with Thompson Hine. I hope you found the information shared during today's program valuable. We welcome your questions about today's topic as well as your suggestions for future programs. You can email me at tanya.nesbitt@thompsonhine.com. If you would like to learn more about Thompson Hine's environmental group, please visit our website at thompsonhine.com. With approximately 400 lawyers in 8 offices, Thompson Hine is a full-service business law firm recognized for innovation in client services. Our Smart Path approach provides clients with services that are predictable, efficient, and aligned with their short and long-term strategic goals. This podcast is for informational purposes only. It provides general information and not legal advice or opinions regarding specific facts. You may not edit, modify, or redistribute this podcast without permission.